The issue is, how can you ban something where you can't show any harm? But that's exactly what the United States Supreme Court did against TikTok by upholding the ban. And so why I'm jumping in the seat is that I want to talk about, how did the United States just pull this off? Well, number one, let's give zero credit to Congress. These were the lawyers behind the scenes. They knew, in order for the United States Supreme Court not to strike down this act that bans TikTok on Sunday, they were going to have to survive in two areas. One, they knew they had to get around a constitutional argument under the First Amendment. And number two, they knew they had to give TikTok a way out. So what am I talking about? Number one, they knew they were going to be challenged. They said it in the brief. They said it in the oral argument. Your Honor, we expected that people were going to have a problem and challenge the fact that it limits our freedom of speech and our creation, or they were ready for it. And they were able to say, look, we're not regulating in any way what people are doing. We're regulating TikTok and how they're doing it. They were able to reference, hey, look, you can go to a million different sites and you can express yourself a million different ways. They were able to frame it under national security, i.e. public policy, i.e. safety. Well, what does that mean? Well, think about it. Legal age to drink is 21. We know more than you what's healthy, what's safe for you. Look, don't get me started. We can go down that rabbit hole. But that's how they knew that they were going to make this a national security issue and not a First Amendment issue. Number two, they knew they had to provide TikTok a way out. Now, the devil's in the details, and it's a lot more complicated than that. But at the bottom line is, they knew if they wrote an absolute law that just restricted TikTok and said, hey, you're out, would not survive the scrutiny by the United States Supreme Court. So what did they do? And here's the brilliance of the government's lawyers. One, they said, look, if they change their data collection policies and their control, then you're able to still move forward and operate in the United States under this platform. But the question still remains. Zero harm. And I listened to the oral argument from the United States attorneys. They got hit by the justices, and they said, look, all these things that you're concerned about, the spying, the espionage, the brain control, is any of it happening? And the answer was no. The Supreme Court literally referenced it, and this is what I call the boogeyman theory. In the United States, if public policy, i.e. national security, is strong enough concerns, this is what the United States Supreme Court said. Sound policymaking often requires legislatures to forecast future events and to anticipate the likely impact of these events based on deductions and inferences for which complete empirical support may be unavailable. Said a different way, we have no evidence. We're afraid this is going to happen. We can't show you that it in fact is happening. The boogeyman. Number two, the Supreme Court references in the order, in their ruling, that even if China has not yet leveraged its relationship with ByteDance to access U.S. TikTok users' data, petitioners often offer no basis for concluding that the government's determination that China might do so is not at least a reasonable inference based on substantial evidence. Stop traffic. What they're saying is the fact that it might happen. They're acknowledging that China hasn't done anything wrong, but that they have the ability to do so is enough to invoke that ban. Now, from a trial lawyer, that drives guys like us nuts, because we know when we have to file a lawsuit, in any case, we have to show damages. You get in a car accident, the accident's not enough. We have to show that you've been damaged. If you want to change a time-sharing plan, i.e. custody on somebody, and you say, look, we want to take mom or dad's time-sharing away, it's not because we're afraid they're going to do something in the future. We have to be able to show that it's happened now. The fact is, you have to have some kind of evidence to show that somebody's been damaged. So as a trial lawyer, it infuriates us to say you're building up a law and an enactment on something that might happen, where you're saying from a public policy argument, we're trying to protect you. Much easier to make that on a something that we can see, controlling forest fires, DUIs, regulatory agencies, rather than saying, hey, on an app where millions of people use it for income, to build businesses, we are going to crush this thing because we're afraid of what might happen to you. It's not the fact that whether the United States or a state can make a law. The question is whether they should make a law. And the biggest kicker of all is the Supreme Court, in their order, notes, we thus afford the government's informed judgment substantial respect here. And ultimately, that's what took down TikTok. Think about that for a second. The government's informed judgment is enough from a policy-making standpoint to carry the day.